My name is Isaac Ruto, Vice Chair.
Thank you.
Afternoon, Judge. Jacqueline Ngutia, Commissioner, you're welcome.
Thank you, Commissioner.
Good afternoon, Judge.
Thank
My name is Caroline Zilani, Commissioner Karibu.
Thank you.
Good afternoon, Judge. Good afternoon.
Good afternoon,
My name is
Commissioner.
My name is Charity Kisotu. You are welcome.
Asante.
Good afternoon, Judge.
Good afternoon, Commissioner.
Mwanza Ombati. Karibu.
Asante.
Good afternoon, Jokindungu.
Thank you.
Good afternoon, Judge.
Good afternoon, Commissioner.
Anthony Mrima, karibu sana Judge.
Yes.
Good afternoon, Judge.
Good afternoon, Commissioner.
Fatuma Sichale, karibu sana.
Asante.
Good afternoon, Judge.
Good afternoon, Commissioner.
Olwande Evelyn, you are welcome.
Asante.
Good afternoon, Judge. Dorcas Oduor, Senior Counsel and Attorney General.
Thank you.
Thank you for that introduction. Judge, you can start by telling us your county and your ethnicity.
Okay, I come, thank you, Chair. I come from Baringo County, and I am a Tugen by ethnicity.
You are a Tugen.
Kalenjin.
Very well. We have looked at your papers and all the material that you supplied us. I'm particularly impressed that you are a doctor of philosophy in law.
Yes.
PhD holder.
Yes.
Congratulations.
Thank you.
This is quite an achievement, especially considering that you did it when you were still a judge.
Yes.
Including even your master's, yeah? 2015, your master's.
Yes.
And 2021, your PhD.
Yes.
Yes, that shows you are resilient, you are hardworking, and committed also to improve your, your scholarship, in addition to being a judge. Now, if you could begin by telling us your vision for the Court of Appeal that you intend to join, your core values, and how you intend to bring them to bear if you are successful in this position of Court of Appeal judge. And of course, you will also tell us the kind of skills and knowledge and expertise that you intend to bring to this court if you are successful. You have 5 minutes to do that, Judge.
Thank you, Chair. To begin with, I have an experience of 23 years as a High Court judge. And within this period of having gained experience, I intend to bring to the Court of Appeal the various jurisprudence that I've developed over time when handling matters in various stations in this country. So that experience alone enables me to have a high stage entry to the Court of Appeal, and would be beneficial to the Court of Appeal. And in the process of also serving in various stations as a High Court judge, I managed to, to develop various jurisprudence arising from various stations and which relate to the local community, and I would wish to bring that to the Court of Appeal. Secondly, I also possess great interpersonal skills or relationships, and I would wish to bring these to the Court of Appeal. What I can only explain that, I can explain that in a short while, that in the process of serving in various stations, and particularly in Kericho, I managed to use my interpersonal relations to promote, discussions with the local communities, leadership, and in the process, I managed to do two things. One, we managed to secure a court premise in Kericho, having had a very good working relationship with the community and the leadership. So we eventually had a new court established in Kericho, known as Jeb Kemel. And that expands now access to justice. In the process also of this interpersonal relationship with these communities, we managed to spread the gospel or promote the use of AJS. That's another form of, creating multi-door approach to the judiciary, to justice. So I would wish to bring this skill to the Court of Appeal, where we should be able to engage with the stakeholders and come on board and promote the use of AJS in the Court of Appeal. 2, 3, the other skill which I think is important and which I possess, which I should bring to the Court of Appeal, is that I have developed with time excellent research skills, which I obtained when I furthered my studies and at the same time while doing my job in the High Court as writing judgment as a judge. So that skill will be very, very important for me to bring to the Court of Appeal. I think those are among the few that I can, yes.
Okay. We will interrogate that more in the process of this interview. Commissioner Mwanza will take it on from here.
Thank you, Chief Justice. Judge, one of the key attributes of judging or judgecraft is the attribute of judicial courage. Perhaps if you can tell us 2 or 3 key aspects of that attribute, and in your long serving career of, you said 22 years, where you've applied it.
Thank you, Commissioner. When we talk about judicial courage, is a state in which a judge should be able to make difficult decisions rightly and not just to easy decisions. And that's when now you can say there is judicial courage. And in order for one to have judicial courage is to be, first of all, to be impartial. You have to be impartial. And secondly, you have to apply the law strictly in determining decisions. Though they may not be popular, these decisions have to be made rightly within the law.
And where you've applied it?
Okay, I can give one instance where I have applied. I remember dealing with a case where it's a recent case actually, where there was riots in a school. Then, of course, there was destruction of property, and eventually the school management met and imposed high penalties against the parents to, of course, to compensate or to rebuild what the students have destroyed. So the parents, through one of their representatives, filed a suit claiming those charges were high, they were unconstitutional because the parents were not involved in it, in setting, or they were not involved in trying to set or calculate the kind of damage. So I looked at it. Of course, the evidence, I had both sides. The evidence, I looked at it. At the end of the day, the decision had to be made. And the school was able to show that, yes, all the parents were involved. And of course, the suit was meant to cajole to see whether the judiciary can step in favor of the parents. I had to make a decision and say, no, we have to see how we can tinker justice and see how the parents can be involved. But it came out clearly that parents were involved in the process, but they just wanted to cut shortcuts. And
sorry. Yeah. Thank you, Judge. I want us to look at Article 19(3) of the Constitution.
Yes.
Judge, Article 19(3) provides that the rights and fundamental freedoms in the Bill of Rights, 1, belong to the state, to each individual, and are not granted by the state. And 2 and B, do not exclude other rights and fundamental freedoms not in the Bill of Rights, but recognized or conferred by law, except to the extent that they are inconsistent with this chapter. Judge, which are these rights that are not in the Bill of Rights?
I think these rights what I can say,
yes,
these rights you can get them through statutes. Some of them are specified in statutes.
yes,
And others are found in international treaties and conventions.
okay,
And thirdly, I think also some of these rights can be found in judicial decisions.
okay.
Yes.
Now I note in your address in the beginning you say that you're a judge who applies the law strictly.
Yes.
Is that the case?
Yes, I apply the law strictly. Of course, there is the element of when you are interpreting the Constitution,
Okay.
you apply the purposive interpretation.
Okay.
Yes.
Judge, there is a case that you decided, the case of the Attorney General versus Kabuito. You're aware of it?
Yes, Kabuito, yes.
So this is a case that was filed in Nairobi against the Ministry of Local Government then for a contractor who had had a contract to build or repair roads, certain roads in Nairobi.
Yes.
And in that judgment, in your judgment, or rather in the plaintiff first, the claim against the contractor was for 1.26 billion.
Yes.
The matter was brought to you as a court. You heard it and you granted the sum of 3.37 billion.
Yes.
So the claim was for 1.2, but in your judgment you give 3.3. Now, the interesting thing about this case, Judge, is that when you had the evidence, the evidence of the contract was only a 4-page contract, which was not complete. It was not complete. In fact, what the Court of Appeal says is that the pages that were in the trial bundle for the contract contained the page of the contract where the parties signed, that is the party signatures page, and 2 selected pages containing clauses relating to cash flow forecasts, payment of certificates, payment of compensation. In short, the plaintiff in that case only produced before the court 4 pages, and which were selected pages, and omitted to table the rest for your consideration. So there was no complete contract. Now, when they came to court, they pleaded that there was a verbal variation of that contract. There was a verbal variation, and interestingly, the evidence from the claimant, one of the claimant's witness, was that they were able to do that and under instructions from the permanent secretary then.
Yes.
And in his evidence, he says that it was normal in the circumstances. I think that is now your analysis, for a permanent secretary to give instructions, since he was powerful and could not at any point override written instructions when the work was urgent, like in this case. Judge, you consider this matter with that 4-page incomplete contract and a verbal variation, and granted a 3.3 billion award. So there was an appeal to the Court of Appeal, and the court severely criticized your judgment, saying that there were two destructive versions relating to the existence or non-existent of this contract, and number 2, there was an alleged verbal variation of this contract. Ultimately, the Court of Appeal set aside that judgment, but from the judgment of the Court of Appeal, there is a lot of criticism on that judgment, that there was no evidence before the judge to support the finding on the ingredients of the contract, and that even if there was a verbal variation, it did not follow the regulations in terms of the public procurement. This is a discussion. It's not an attack on you. It's just a discussion for purposes of the interview, and also for purposes of accountability. What do you say to that?
Okay. I think the way I appreciated maybe the evidence given,
Yes.
by the contractor and his witnesses,
Yes.
must have influenced my reasoning, and I must have stated in the because they were talking about, and I remember these were where there were floods destroying infrastructure, and then the reasoning given, or the verbal instructions given by the peers, sort of carried the day, because there was no one time you would go this is an emergency somehow. So,
Yes.
and I believed his evidence that that is how the government operates during emergency. So that's what influenced me.
Okay. And Judge, what about the contract? There was no complete contract that was tabled before the trial court.
I remember I saw a contract, unless it was mutilated, I don't know. Because I remember I saw the contract.
Okay.
Yes.
But would a variation of a contract orally escalate a cost without going through the process from 1.2 billion to 3.3?
As I told, okay, it may, depending on how they really argue their case, because they were so passionate, saying yes, even this you could not even meet, for purpose of dealing with a contract, because it was an emergency, infrastructure and all that. So I believed the evidence of the contractor given out by that the PS had the power to alter orally the contract.
Okay.
Yes.
But the Court of Appeal says that the requirements of that contract, the requirements to formation of an oral contract were not met, and that courts ought to be concerned, especially where oral contracts exist, to ascertain that the terms indeed reflect the intention of the parties. So there were opposing views, both destructive to the contract. On one side, the respondents or the defendants in your case say no, there was no contract. The opposite say no, there was a contract. Then wasn't it necessary for the court to consider number one, whether there was really a contract, and examine first the entire contract? Because what was before you was a 4-page contract, which was not complete. And secondly, to also consider whether a verbal contract will make such a significant variation from 1.2 billion to 3.3.
Okay, what I considered, okay, what you are raising is fundamental in that whether the question is whether a verbal communication can alter.
Yes.
Because I was faced with evidence.
Yes.
Where you notice sort of like the defendant even giving evidence, you would see they're sort of agreeing, yes, they altered verbally.
Yes.
But the extent in which you could alter is what never came out so clearly.
Okay.
Yes.
Thank you, Judge. Thank you, Chief Justice. That's all.
Thank you, Honorable Chief, and Judge, welcome once again. Judge, I know you as a champion of AJS. And what is this agency theory of jurisdiction in AJS?
Okay. The agency theory is quite simple. It is even explained in the policy. This agent, the idea is the party autonomy. When you bring out the party autonomy, it is yes. If you approach AJS, one, that party autonomy or that independence of the party comes into play. And that is why even when you discuss about agency theory, you look at it and say, yes, did the party have that capacity to even represent himself or herself? So, and that is why we, at times when you say, can you apply AJS on matters touching on children, then we'll say yes, the child has no capacity to, yes.
Okay.
Yes.
And in experience with the AGS, what are some of the challenges which are facing the adoption of SJS in Kenya?
Okay. One is the little understanding of what AJS is. That's, so that now, you see, under Article 159, the Constitution directs the judiciary to promote.
Yes.
To promote AJS. Then, and it is presumed that the judges or the judicial officers understand the application of AJS. So we still stuck in the colonial common law position where we say, okay, how do we apply AJS? Because there is need for some training. So we have that lack of people to understand AJS, and that's why in the policy we have to continuously train the practitioners, train the stakeholders of AJS. So that's one of the pitfalls that we lack that communication. We don't have that information on AJS.
Okay,
Yes.
I know there are many other challenges, but maybe we'll discuss these some other time. Just your thoughts on Article 22, Sub-Article 3 of the Constitution. Article 22, Sub-Article 3 of the Constitution gives powers to the Chief Justice to make rules providing for the court proceedings referred to in the article that is on constitutional petitions, on enforcement of the Bill of Rights.
Yes.
And this is what brought about the commonly known as the Mutunga rules. Are we together, Judge?
Yes, yes.
Oh, thank you.
We're together, yes.
Yes. Now, are these rules, which are promulgated under Article 22, Sub-Article 3 of the Constitution, or can they be referred as subsidiary legislation?
Oh, yeah. Okay, I had not thought about that, but what I know is that pursuant to this provision,
Yes.
the CJ has power to set up to set up to refer this on to the Rules Committee to prepare. However, the position we have always taken is that these are just rules to operationalize that provision. And even as we speak now, we are still developing what we call the Koome rules now to replace the Mutunga rules.
Okay, so
Yes.
these ones cannot be referred to as, they're not the same as subsidiary legislation.
The way I
Yes.
understand,
Yes.
they cannot be referred as subsidiary legislation. They're
Okay.
just pure rules to operationalize
The constitutional
the
provisions.
Constitution. Yes.
Thank you very much. I wish you the very best, Judge.
Thank you.
Yes, good afternoon, Judge.
Good afternoon, Honorable AG.
I want to follow up on AJS.
Yes.
AJS is alternative justice systems, is
Yes.
it?
Yes.
It is. What is alternative to what? It is alternative to what?
Okay. That is a debate we had.
No, when we say AJS, it is alternative to what?
Okay, when you talk about AJS, what, from the way we dealt with it, is alternative to the formal justice system.
And who has been created under the Constitution to give the formal justice system?
of course, the formal justice system, of course, is set up under the law, that is the statutes and all that.
No, the system,
Yes.
not the substantive. Who dispenses the formal justice?
It's the judiciary.
Judiciary.
Yes.
So can the same person who has been created under the Constitution to dispense formal justice supervise informal justice?
Okay, it's not supervising. It's supposed to, they are just directed to promote.
But to have nothing to do with it?
Yes, you see.
In your writing,
Yes.
sample writing number 4,
Yes.
you now refer to strengthening the application of informal justice system in land disputes.
Yes.
So are they used interchangeably, alternative justice system and informal justice system?
In that write-up of mine, okay, we cannot say. Of course, AJS is sort of an informal justice system, but you cannot use them interchangeably.
It's okay, I'm satisfied. So
yeah.
we agree that it is alternative to the formal justice system that the judiciary dispenses.
Yes, yes.
Okay, let me go to my question now. In your sample writing number 3, you were analyzing the weaknesses of traditional dispute resolution mechanisms as an avenue of dispute resolution in Kenya. I've not been able to see what your thesis was on or your discipline in your PhD program, but what was your conclusion? What did you conclude here?
Yes.
What are the weaknesses of traditional dispute resolution mechanisms as an avenue of dispute resolution in Kenya?
Okay, I did conclude that yes, these systems at times can also be abused. You know, you remember the weaknesses of the formal justice system. Sometimes say, okay, there is a bit of corruption, there is a bit of undue influence from the external forces. So looking at these ones now, some of the weaknesses are, for example, like maybe using or failing to apply the right of hearing at times. So those are some of the weaknesses in which I saw.
Corruption?
Yes, there's corruption. There is failure even to provide a right of hearing.
And what did you recommend?
Of course, my recommendation was we need to critically examine these systems and make sure that they are aligned with the constitutional provisions.
Finally, a judge, now that you are a jurist and an academician, while the Constitution entrenches Kenya as a multi-party democracy, it simultaneously safeguards the right to contest elections as an independent candidate. From a constitutional perspective, how do you assess the role of independent candidates in advancing political inclusivity and equality? And what implications does this have for judicial scrutiny of electoral processes, particularly when the Court of Appeal is confronted with election disputes initiated by independent candidates? I'm sure we all know that independent candidates are not affiliated to any party,
Yes.
any political party.
Yes.
Yes.
I think it's a minefield, because now, as to whether it contradicts that provision of saying Kenya is a multi-party state, and then down here you are talking about an independent candidate, but the same constitution also provides for an independent candidate. So I think it's a question which can be interrogated. I cannot give a straightforward answer now. It is a question which has to be interrogated with, when you invite dialogue on it, we discuss.
Does it have any implications to inclusivity and equality?
To me, it doesn't, because it's just, you know, it just, you know, it allows these candidates now to come in independently when they are locked out by the parties now who are contesting. But to me, it doesn't affect.
And how does it augur with a constitutional democracy where the sovereign rules?
At times, it's very difficult because now the way our constitutional architecture is that inclusivity, accommodation, and all that. So it is tricky to now come and see how they can fit in. But I think it is a way of, you know, promoting that inclusive. To me, it's not a big problem that can cause any confusion.
What do you mean it's not a big problem?
I'm saying when you now talk about the constitutional architecture of...
Well, this is an independent candidate who has not been nominated by anybody.
Yes.
He's not answerable to anybody.
Yes. So when you talk about the democracy, whether it will affect that...
So maybe we leave it there. Maybe it's a discussion we can have outside this.
Okay.
Thank you.
Thank you, Honorable Chief Justice. Judge, let's now move from issues constitutional and focus on the Employment Act. The Employment Act confers certain rights to an employee. Please name some of these rights.
Right, of course, for pay.
Right to pay.
Yes. Right of good working environment.
Please speak up.
Right of good working environment.
Safe conditions of work.
Yes. Then, of course, there is, when you talk about okay. I think I can remember those two for now.
Okay.
Yes.
I thought you'd even tell us about right to maternity leave, stroke paternity leave, for instance.
Yes.
So those rights are clearly spelled out, eh?
Yes.
Now, there are quite a number. Protection against discrimination, unfair termination, etc., etc. Now, on the other hand, what are the rights of an employer under that statute?
I did not figure out so much, but the rights of an employer, of course, one is to get the services of the employee.
Is that clearly spelled out? And if it is, maybe you can tell us how it is spelled out.
It is spelled out in the, like now, the employment contract.
Yeah, an employment contract is outside the statute. I'm asking about the rights of an employer as contained in the statute. You know the way it is spelled out?
Yes.
For the employee, you can go on paternity leave, you are entitled to wages, safe working conditions.
Yes.
What about the flip side of it?
I think I may not have really interacted so much with the provisions of the Act on Rights of Employers.
All right.
Yes.
But now when you come to the Court of Appeal, You know, we deal with all manner of cases, all manner of disputes, etc. Now, okay, when it comes to laying off an employee who is guilty of gross misconduct, what does the law say? What does this statute provide as a condition precedent before you lay them off? What do you need to do as an employer?
Of course, you have to give them a right of hearing.
Yes.
Then, so that when you have a right of hearing, you apply now the disciplinary procedures and all that.
All right. So there is a charge of gross misconduct, and the statute provides that that employee, you must subject them to due process. Is that correct?
Yes.
And I'm sure you may have read very many cases emanating from our courts which have found that even if there is gross misconduct, but if there was no due process, that termination is unlawful.
Yes.
Now, the question that I have for you is that under Article 159(2)(d) of the Constitution, courts are directed to dispense justice without due regard to technicalities.
Yes.
Why then is an employee not lawfully terminated if the procedural technicalities were not followed?
I think the cardinal rule is the impact of the provision that you have to have a hearing. I think that's the cardinal. It is a rule that the constitutional provision that you have to have a fair or hearing. So and I think that is where I think the courts have come from to determine that issue.
I'm asking.
Yes.
Article 159 says you need to dispense justice, but you don't have to have undue regard to procedural technicalities.
Yes.
But then here you have a statute which says you must subject this employee to those procedural technicalities. So where is the point of departure, if at all?
What I am grappling with is whether we can categorize those provisions subjecting the employee to a certain process, whether they are procedural technicalities.
That's it.
Yes.
Why are they not?
Yeah, because if you are supposed to be subjected to a trial or subjected to a hearing, it wouldn't mean to me, it wouldn't be procedural technicality, because it is, you are just complying with the statute in compliance with the constitutional provision that you give them a hearing.
Judge, I hear what you are saying.
Yes.
But finally, what have our courts said as regards the interpretation of Article 159(2)(d) on procedural technicalities?
Yes, what I know is that the courts have, even the provision itself is very clear that don't apply technicalities. And that's why when I go back to what you just asked me is whether these procedures that you pointed out in the Act, whether they can be considered as technicalities or sort of it's a process.
So for you, the answer is that you cannot equate those procedural technicalities with what Article 159 speaks of.
Yes, that is the view I have.
All right. Thank you. That's all, Chief Justice.
Good afternoon.
Good afternoon.
Now, in Murwatetu, the Supreme Court laid out the differences between an amicus and an interested party. What can you tell us about the differences of those two parties?
Amicus and
An interested party.
okay, I may not have interrogated so much that whatever, but what I know is that there is a whole world of difference between amicus and the interested party. So that now amicus will come in to, if they are to propound issues which are so important and can affect the decision in terms of promoting what principles are supposed to come out from the suit or the action. Then interested parties, of course, are those who are likely to be affected by this decision.
Okay. I don't know if you're familiar with the Supreme Court decision in Methodist Church versus Fugicha. It's commonly known as the hijab case. Are you familiar with that case?
Okay. I'm not so familiar, but I know I read something about an analysis on, yes.
On that?
Yes.
The Supreme Court said that an interested party cannot become the main petitioner from the High Court to the Court of Appeal.
Yes.
As he's not the owner of the case per se.
Yes.
Okay. Can you tell me about the advisory opinion jurisdiction by the Supreme Court? Who can bring an advisory opinion to the court?
What I have read is that person who can seek for advisory opinion, the national government, the county government, and state organs.
Okay.
Yes.
And a body such as the Council of Governors, can that be considered as a state organ who can seek an advisory opinion or not?
Because this Council of Governors is just an organ representing all the governors.
Yes. Is it a state organ?
I think unless it's not a state organ, but it can be one of the bodies which, if we interpret the constitutional provisions on who can seek, maybe we can expand that and then put it as. Yes.
Okay, thank you so much.
Thank you so much, Honorable Chief Justice. Good afternoon once again, Judge.
Good afternoon, Commissioner.
Okay, I'll ask you a few questions with regards to your sample writing. I've looked at your sample writings, and they comprise of 3 judge bench judgments, 1 co-authored article and 1 single authored article. They demonstrate your strong judicial and scholarly competence. Do you need water? Sorry, I forgot to ask. That is usually my role.
Thank you.
You're
Yes.
good now, Judge?
Thank you.
Okay, good to hear that. So your sample writing reflect clear issue identification, sound application of constitutional and statutory principle, coherent reasoning, proper use of precedent, and you use a tone. Your tone is professional. So in your journal article, so I must commend you for the sample writing you shared, and keep up the good job on writing good decisions. You the journal you shared, the one of the African Nazarene on AJS, the conclusion you summarize the dilemma and you reject the codification of AJS as a solution to what we are with the fragmented way of how AJS operates, and you did provide very strong recommendations. One of it was regulatory framework setting minimum standards, capacity building, and defined supervisory role of the formal courts, by the formal courts. So do you think with the current AJS policy, any of the recommendations you had provided have been catered for? If yes, please explain. If no, also explain.
Thank you, Commissioner. I think by the time I was writing that, I think we were still developing the policy.
Yes.
And I have come to a different conclusion now, that yes, we don't need this regulatory framework. What we need is a policy which will make now the operation of those AJS fluid, so that you don't hamper the use of AJS.
Okay, and the defined supervisory role by the courts, has that happened? And if yes, what is the current status?
Okay, the supervisory role by the courts, we were looking at it from a limited window, so that now what the court can only do is to look at the AJS. You look at the propriety, the procedural, whatever, and then you make sure that these decisions align with the constitutional provisions, so that it's only making sure that it is within the law. Okay. And yes.
And does that strictly apply to matters that have been referred by the courts to the AJS, or any random AJS? If my elders in Ebusuvi sit to decide a matter, can the court supervise that, even despite the court not having referred it, or only with respect to matters referred?
It will be in respect to matters referred to court, and also if it comes to the attention of the court, then they will be able to take up.
Okay,
yes.
Thank you. I'll ask you a lot of questions around AJS, because I know you are a guru, yes, in that area. So the agency theory, you have rightly described it earlier when Judge Mrima asked you the question. What it speaks to is that the theory does not distinguish civil from criminal. Instead, it asks an objectively determined that the parties to a dispute give consent voluntarily and submit themselves to AJS. And the consent of the parties can be objectively and credibly be determined to be informed and free. So if the answer is in the affirmative, and there is no specific legislation or public policy hosting the jurisdiction of AJS, then the dispute is amenable to AJS mode of dispute resolution. So what this theory is saying, it doesn't matter whether it's a civil or criminal matter. When you look at criminal cases, you normally have two parties, the defense and the prosecution. Within prosecution, there is a DPP and the complainant. So when this theory speaks to a party, consent of parties, in criminal matters, who is a party? For you to now say there is informed consent and parties have agreed to freely submit themselves to AJS. So within the criminal justice system, who is a party?
Okay. What we did, or what that provision speaks to, the parties are the accused person who is charged, and the other, of course, the victim or the victim's family. So those are the main players. But it will become a totally different animal when it now comes to issues related to plea bargaining, where now the AG comes in. So the parties, the presumption is the key parties now, these are the key parties, but the DPP plays a role, because at the end of the day, if the parties agree and they say, okay, we want to have this criminal case withdrawn, the AG, the DPP has to play a role. So, but the main players are the victims and the accused person. But without the participation of DPP, it will be because at the end of they may require the withdrawal of the case. And the only person who can withdraw the case is the DPP.
Okay, because I'm aware currently there is tension between the judiciary and DPP with regards to that particular agency theory and their powers under the Constitution to prosecute cases. So I just needed your thoughts around that.
It is true, Commissioner, and we are working out.
So you're working with the DPP?
We are working out with the DPP.
Okay.
We are having a very, very robust discussion.
Okay.
Yes.
Okay.
But so far, so good in terms of when we are dealing with plea bargaining.
Plea bargaining.
Yes.
Okay. But the plea bargaining, the DPP is still involved anyway.
In fact,
yes.
it's the
he's involved. He's the main person.
The main player.
Okay.
Yes.
Thank you, and have a good afternoon.
Thank you.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, Commissioner.
So I want to take us to the SOJA report of 24-25.
Yes.
And the concern around, or rather the complaints that Kenyans have with the judiciary or against the judiciary. What, in your view, is the leading complaint by Kenyans against the judiciary, especially in respect to court services?
I think the leading complaint is delay. Delay in concluding cases.
Okay, from the statistics we have from SOJA.
And adjournments, sort of.
Yes, there was adjournments and delay in concluding cases, which is, they are correlated, but mainly also delay in delivery of judgments and rulings.
Yes.
So now, we all know that it is statutory. The period within which you are supposed to deliver a judgment or a ruling is statutory. Number one, I want to ask, what is causing the delay and why is it that we are unable to meet those timelines? And number two, how can we improve on this or address this situation?
Okay. There is no one reason that you can say could be the main cause, but one of the reasons that cause delay is the number of cases a judicial officer handles may do more than what you can churn out. So it's the question of backlog, and of course other factors like maybe parties have been applying for adjournments, and we are unable to refuse those adjournments.
Allow me to interrupt you,
Yes,
Judge,
yes,
in the interest of time.
Yes.
I'm specific to delays in delivering judgments and rulings, yet we have statutory timelines. So generally, the complaint here is that you will hear the case, you will conclude it, but now when it comes to delivering the judgments and rulings, nothing is forthcoming.
I think it really affects an individual judicial officer or a judge.
Mm-hmm.
So depending on how you manage your timelines, it becomes now individual in that the delay would be you've taken more than what you intended to deliver, so you have so many, and then the fact also is that you've not reserved time or preserved time for preparing your judgments and all that. Otherwise it can also be laziness on the part of the judicial officer or the judge.
So you are saying it's a question of managing your time?
Yes.
That is one of the leading causes?
Yes.
So what is the solution you would propose to address this?
To me, it is, because it is also another issue, is how to it's a question of now us, having dialogue. This, you see now the judicial office, so that now we are able to discuss how, or give ourselves, training in which we are able to deliver within the given timelines. So it's a question of training and maybe mentoring ourselves in terms of seeing that we comply with the timelines. And also, of course, I know there is that sanction saying, okay, if you don't deliver within this time, you need to report. Perhaps maybe this time we can enforce, see what sanctions can be put in place. If you don't deliver within the timelines given, what sanctions should be done. So perhaps now our supervisors can do that.
Now, I'm curious about what you would propose as sanctions to address the situation.
I think I don't want to propose.
You want to just suggest the sanction, but you don't want to propose it?
Yes.
Yes, the reason I'm asking is because there's been a lot of concern around that issue of delivery of judgments and rulings. Earlier in the morning, we had a discussion with another candidate, and it was pointed out that we even have situations where judges, instead of uploading their judgments in the CTS, they upload blank papers. We've also had concerns around judges giving a mention to give a date for judgment after submissions had been filed. So I wanted just to give an opportunity to highlight what are the challenges, what is causing this, and how we can address them.
I get what you're saying about some of these causes, like now when you talk about some judicial officers or judges posting blank papers, or the decision but not the reasons. These are issues which we really need a lot of soul searching. We need to deal with them, and we need to identify also, at times it can be a blanket accusation, but we need to identify also who are the culprits, and then we confront them.
Okay, we can now go to your report from DISPOP. I'm assuming you've been given a copy, and if not, at least you've taken time in preparation for this interview to look at your report from the CTS.
Yes.
Now, the report I have here is for the period between July 2025 and September 2025. It is indicated in that portion of the report that there's only one judge in Kericho where you are alone.
Yes.
So of course then there's no one to share and compare who is carrying the heavier weight. All of it is carried by you. But I wanted to engage you on your returns for the financial year 24-25, especially on judgments. According to the PMMU, I'm sure you know how many judgments per month a judge is supposed to churn out, and therefore also the total per year.
Yes.
Yes, it's supposed to be 10 judgments per month, 110 per year, of course factoring in leave. So now, according to the report I have here, they say that you only did 24 judgments in Kericho in the financial year 24-25. Maybe you can confirm if that is accurate, and if it is, why that is so.
Okay. I've not known this, but what I know is it may not be true. So I think maybe my report, if I had been given earlier, I would be able to know. Because what I do per month, I churn between 10 to 15 judgments and rulings per month. And that has been consistent. So unless maybe they were not posted, or I don't know.
I'm looking at judgments purely. I've not looked at rulings. Of course, they have a report on rulings, which are quite a number, as you have said.
Yes.
In that same period, you had 226 rulings that closed cases and 52 that did not close cases. But I was being specific about the judgments.
Yes.
That are 24. Maybe you will confirm, because that is the report we have. If you feel it is not accurate, maybe you will confirm and then furnish us with the accurate data.
Yeah, and again, these judgments could be mainly, I don't know whether they specified criminal or civil.
No, it is not specified. They just
Yes.
gave a total of
Because
24.
what I know, it takes a long time also to conclude
A criminal
a
trial.
criminal trial. So most probably that is one of the areas where we...
But you are doing quite well when it comes to rulings that close the case. I don't know if this would be speaking to also the alternative dispute resolution mechanisms.
Yes, in fact, if it's only I didn't bring the data, the number of cases that were determined using AJS really grown.
Okay.
Yeah, yes.
I think that's commendable. Thank you, and I wish you well.
Thank you.
Thank you, Honorable Chair, and welcome again, Judge. Judge, I'm on this side.
Yes.
Okay. So how do you reconcile judicial oversight, independence, and accountability? And what checks and balances exist within the judiciary to enhance accountability?
That's a mouthful.
Can I repeat or you?
Yes, repeat,
Okay.
Commissioner.
Yeah, so how do you reconcile judicial oversight, independence, and accountability? And what checks and balances exist within the judiciary to enhance accountability?
This I think, of course, when you talk about oversight, judicial oversight, the judiciary, of course, oversights. Okay, the judiciary has a role in oversighting several areas. Like, for example, if you want to question the decision-making process of bodies or individuals, you are oversighting. That's your oversighting. When it comes to accountability, now you're talking about the judiciary playing a role in when you talk about the judiciary plays a role in accountability in that they are able to show through their judgments, through their rulings, the outcomes of whatever decisions they have done. So they are accountable, they are coming out openly. Then when it comes to checks and balances, like now when you talk about checks and balances, I know there is a vexing question, okay, who oversights judiciary? and that's a question which is still ongoing discussion up to now. Like at times when you look at the financial management or the financial issues touching on the judiciary, who oversight? When you read other materials, it says, okay, it's being oversighted by Auditor General, is being oversighted by at times EACC and all that. But it's a question of discussion which ongoing. Yes.
Now, and how will you balance the constitutional imperatives for expeditious justice with limited judicial resources?
I think the judiciary has taken steps, of course, to utilize the little resources that we have. Through the budget process, you budget, see how you can utilize that, so it's a question of really balancing. Yes.
Do you do prioritization?
Yes, what I read when like now when we sit as an LMT, where I head, we give priority as you budget. Mm-hmm. So you prioritize what the finances can accommodate. Mm-hmm. And the rest we go on begging to the treasury to give us more money.
Okay. So finally, you talked about integrity and the views we have received from the stakeholders. Nothing has been raised against you on issues of integrity, at least that have been brought to the attention of the Commission. But what will you do if you became aware of corruption allegations involving one of your colleagues in the bench?
This one, first of all, I will take it up myself and have a discussion with such a colleague. That's one. So that we now, we have a discussion. And then, of course, the other step will be to report to the presiding judge or our superiors. Mm-hmm. Yes.
Okay, thank you, Judge. I wish you all the best.
Thank you.
Thank you, Honorable Chair. Judge, I have a few questions for you. And maybe you can begin by telling us what is the difference between emotional intelligence and IQ?
Okay. When you talk about IQ, we referring to the cognitive ability to reason, logic, and that. Then when it comes to emotional intelligence, it's a question of managing emotions, how to deal with, your space with others.
Okay. Yes. How do you demonstrate the use of emotional intelligence in your work as a judge?
Okay. At times, like now, if I'm a presiding judge, at times you would have issues raised by the staff, or there are complaints against the staff, maybe drunkenness and all that. Then you are able to apply empathy, knowing how to assist these employees or these staff, and then you are able to deal with them. Or like now, when you are in also a court setup, at times you get submissions or someone trying to abuse the court. So you should be able to appreciate that there are instances where your temperament is being questioned. You are instances where could be some people are undergoing, certain challenges, so you are able to appreciate and see how to come in and assist.
Okay. What is your understanding of diversity and inclusion, and do you think it's important in the judiciary? While at it, you could also tell us ways in which you can promote diversity and inclusion.
I think this one speaks to our constitutional architecture. So that we need to promote diversity. We need to promote diversity and inclusion. And that's why even in this interview, they're asking you, where do you come from, your ethnicity, and so that we are able to relate. We could be diverse, but at the same time we coexist. And there is also the question of inclusion, so that you bring that aspect of inclusivity in our setup as a judiciary.
Why is it important?
It's important in that this promotes now our unity as a country. Yeah.
Any other that you can think of?
Okay, I think that's what I can manage.
Okay. In your career, is there a mistake you ever made that looking back and given an opportunity, you'd go back and correct it?
I don't remember one for now, but because I believe maybe if there were mistakes, maybe those infractions, those small mistakes, not something that you can easily remember and forget.
Okay.
Yes.
Thank you, and I wish you well, Judge.
Thank you.
Yes, again, Judge, I hope you are not tired yet. Now, what is your understanding of the role of international courts and tribunals in complementing national systems?
Okay. What I know is that like when we have international courts, like the East African Court of Justice, these are specifically set up. These courts are set up to, like now for the East African Court of Justice, set up to interpret the application and practice of the treaty. And it deals specifically with the under the provisions of that treaty, and and at times our like now, like if we are confronted with issues like now human rights, they can also be dealt with at the national level and at the regional or international level. But when it comes to the relationship now between our national courts and the regional or international courts, the idea is the national courts will be given a chance to conclude first their matter, if at all they are there, that complementarity, so that now you don't eat into the jurisdiction of our local courts. Thank you.
Okay. How do you ensure that international best practices are adopted while remaining sensitive to local context?
Okay, international best practice, like now at times we look at the decisions as a court. We look at the decisions of international courts, and we borrow some of the best practices. Like now, when we are dealing with cases touching on human rights, and we borrow the best practices from those courts as persuasive. We borrow their decisions are persuasive, and we cannot say yes. They are persuasive because they are not supposed to really influence us, but the application of international decisions, or the citing of international ways in which we can borrow from them. Thank you.
Thank you very much, Judge and the commissioners. There's just one clarification I wish to seek from you when Commissioner Orwande asked the problems that impede access to justice and that brings tension between us and the public. You said it is delayed judgments and rulings. I want to hear from you clearly because what systems have you put in place, especially as the PJ in Kericho, to ensure that there is accountability in that area? Because if we have a problem, we have a problem, and we must address the root cause of it. How are you addressing the root cause of the delayed judgments?
Thank you, CJ. I know this issue has arisen in where I preside. And what I did as an innovation is to have what we call a bench meeting, monthly bench meetings, where we are able to and monthly bench meetings for the judges and the magistrates who serve there, so that such issues, because we also have an open door policy, where if there are delayed judgments, normally we have a report box, we have a report office that we've encouraged the parties, the lawyers, to post if there is any delayed judgments. So in the process now, as we have our bench meetings, we are able to discuss such. And then, of course, in my individual capacity, I will also be able to call upon my colleagues, the judicial officers and the judges, say, okay, here there is a complaint. So that's that's an innovation which I've done in Kericho.
Is the system able to tell you the rulings and judgments that have been delayed?
Yes.
The head of station?
Yes.
You are able to get that?
We are able to get that. What we normally do is to ask apart from reports from members of public, also to ask the judicial officers to post. Because we have our own WhatsApp group also that we have our forum to talk.
Other than delayed judgments, Judge, I think another problem is the issue of corruption. How are you dealing with it in your station?
Okay, thank you, CJ. The issue of corruption, we are dealing with it this way. And it has really worked, and I like your directive where you say you need to set up, we set up that integrated committee where I now chair, and we sort of drafted our own rules of engagement where we where we adopted a policy where you can report to that committee, and we have a box where you can post. Then in our monthly meetings, which we do, we discuss those complaints, and we even confront now we deal directly with the officers who are being mentioned. We just talk to them, and then of course we post our monthly minutes on those issues to your office, CJ. Yes.
Very well. Judge, I think this brings us to the end of the interview, but we always give a candidate an opportunity also to engage us, and I give you this opportunity now to engage us.
Thank you, CJ. I first of all want to say thank you to the Commission for giving me an opportunity to appear before you for this interview. And secondly, I also want to join my earlier colleagues to pass a message of condolence for the loss of the Honorable Justice Ibrahim. We are very sorry for that. And finally, thank you for appreciating the work that we do. Thank you.
Thank you. Thank you, Judge. We wish you all the best. We will get in touch with you when we complete the exercise. It's a very competitive one, but we wish you all the best and encourage you to continue doing the good work of serving the people of Kenya and the NJS and the people of Kericho as their presiding judge. You are now released.
Thank you.